The Uganda Human Rights Commission recently indicated that cases of human rights violation and abuses skyrocketed during the 2021 general elections. The Commission has a backlog of over 1,000 cases, majority of which are attributed to security forces torturing civilians. However, the latest decision by the East African Legislative Assembly, Ugandans who feel that their rights have been violated can now opt for the East African Court of Justice. The regional lawmakers have recommended the extension of the jurisdiction of the East African Court of Justice to also start hearing cases of human rights violation and abuses in the 6 partner states of the East African community.
Urge the Council Minister to extend the jurisdiction of the East African Court of Justice to include human rights and other matters and appoint judges of the East African Court of Justice. Citizens of the partner states will be given the rights to file cases at the East African Court of Justice regardless of wherever they reside.
Currently, the EAC Treaty limits the court to dispute interpretation and application of treaty provisions like dispute between partner states and arbitrations.
But I think the time is ripe for Council to take action and expand the jurisdiction of court. I'll give you examples. I remember there's also a matter from Uganda, the famous Katabazi case. Actually, this involved people who had been released on bail by court, and then they were rearrested.
Of course, I'm wondering, what is the cause of the delay? If our countries can be members of the ICC, and we try to cooperate with the ICC, why would we not establish this by extending the jurisdiction of the court so that we settle some of the issues here in this court?
How can we claim to have a court which decision cannot be implemented by the partner state? It's like we have a toothless bulldog that can only bark but do not bite.
What are you afraid of, Council? Are you afraid that there will be exposing things, or are you afraid of their ability to judge human rights cases?
Some of the reasons given were that, you see, even we have the African Court there that deals with human rights matters. So why should ESCJ also deal with human rights matters? But ask yourself, who is the beneficiary at the end of the day? The beneficiaries are the residents of the committee, and personally I see no reason if we can have many courts dealing with human rights at different levels. That will enhance integration, because we are not going to integrate if you are not sure of protection of human rights. It is a precursor to integration. And that is why if you look at our court, there are so many cases challenging action of our partner states doing this, doing that, which they say is a violation of their human rights and also a violation of their treaty.
The Assembly has also voted to lift the time frame for filing a case with the East African Court of Justice. The treaty puts a limit at 2 months, which according to legislators is a denial of justice to the East Africans. Unlike other courts in partner states that are presumed independent in their operations, the East African Court of Justice does not have full autonomy, and the judges work on the ad hoc basis and are not resident in Arusha.
And you must carry out your oversight function when you are independent. Because if you are not independent yourself, then you cannot carry out an oversight function to monitor or to audit what your master is doing.
If the recommendations are adopted by the Council of Ministers of the East African Community and the heads of state, Ugandans will be able to take their cases of human rights violation to the East African Court of Justice. Jingo Francis, NTV, in Arusha, Tanzania.